It's fantastic to have you all on. Thanks, Rachel. And good morning, good afternoon, and hello to all of you tuning in from across the globe. I'm really amazingly, fantastically pleased. Lots of mixed descriptions. We've got nearly, I think, just over 200 people who've registered for the webinar today. And whilst there's 75 currently on, it means 200 people are going to benefit from the handouts. They can log on afterwards. You'll get an email to be able to download the video and the rest. And there are over 53 different countries who've signed on, which again shows the reach of FIDIC, and also shows just how good our speakers today, Donald and Malith, are for people tuning in. So I'm really delighted that so many of you are participating, and I hope that you'll find this webinar enjoyable and a very informative experience, regardless of your area of expertise or your experience with FIDIC, whether you've used it a lot or perhaps you're only just coming to it. There are a few of the dull housekeeping rules. At least you're on Zoom. I don't have to tell you to turn your phone off or tell you that if in the event of a fire alarm or anything else, exit. I presume each of you knows how to get out of your house. Whilst it's on Zoom, we do use the meeting function. I know it's a webinar, but that's so that you can have your picture up. You can send chat during the talk. If you can just make sure that you're all muted, but I say you don't need to turn your cameras off. You can also edit your name on your photograph. So if you want to edit your name, if you click on the top right hand, there's some little dots where your picture is. You can edit your name to put your country or your company or whatever. It may help other people to recognize you. Please feel free to do that. It would be great if you can, all of you, put into the chat box the country you're from and which form of FIDIC you've used most. And also, it'd be quite interesting today, given the subject of Malith's talk, if you could say whether you're still using the 1999 or whether you are now, you've moved right up to date with 2017. I'll come back to that. So those of you who don't know me, I am Bill Barton. I'm one of the directors of Barton Legal. We are a specialist practice based in England, specialising in construction law. Just last week, we won the Technology Venture of the Year award at the British Legal Technology Awards. So if anything goes wrong, then it really is our fault and there are no excuses. As you know, we've got two speakers today. So we've got Donald Jarrett, who I'll give a full introduction to each in a minute, but Donald's going to be given a quick introduction to FIDIC, which is really a reminder of all the things we know, but we've perhaps forgotten or don't think about. And then he's going to explore the relevance and importance of the applicable law and the vital link between country and contract. And then Malith is going to be looking at all the things we really want to know about the 2017 edition of FIDIC. So for those of you who are still clinging to the 1999 version, these are going to be the reasons why you need to go out and buy the new version. And those reasons range from improved definitions, details as to the engineer and a more tightly defined role, the operation of notices, and also some of the overriding changes relating to, for example, deeming provisions and liability. I would just also say that, of course, the 2017 version will be 4 years old next year. So if you're using the 1999 version, you really are starting to get a bit out of date. So Malith and Donald met at a Dispute Resolution Board Foundation conference many years ago in Jakarta in Indonesia. They apparently walked back up the hill to their hotel, talking all things FIDIC, as you do, and realised that they got on so well, in fact, that they decided that they should work together, and they've been doing that ever since. Between them, they have innumerable connections and clients across the globe in both the legal and engineering spheres of consultancy, arbitration, construction engineering, as well as countless other areas of expertise. So I'm going to give them both an introduction now, because then Donald is going to go through his slides and then straight into Malith, and then it'll come back to me at the end. So just remember, try and put in the chat which country you're from, which form of FIDIC contract you're using, and whether you're using the 99 version or the 2017. And then at the end, don't run away, because there are some competitions and you'll need to stay to the end to find out what to do and to find out about our amazing quiz in December. So first of all, Donald. Well, I've known Donald a long time, and Donald's very kindly agreed to stay up late tonight. So it's gone well past his bedtime. It's after 10 p.m. He's been an engineer for over 30 years, turned barrister, construction law practitioner, arbitrator, expert determinator, mediator, and a member of various dispute boards. Donald was voted as the best construction law practitioner in Australia for 2016. What an accolade. And also named as a thought leader in construction for 2019 and 2020 by Who's Legal, an honour that was only given to 67 other people globally. He's a senior fellow at the University of Melbourne, occasionally teaches a master's course on international construction, never asked me, and in this he's also published many books, 70 academic papers, author, co-author, editor of 5 books, most recently the International Application of FIDIC Contracts, a Practical Guide. I'm not sure, but Donald will tell you when that's coming out. He's a FIDIC accredited trainer, a member of the FIDIC's President List of Adjudicators, and clearly commands immense respect. I love Donald because he's honest, open, unflinchingly inclusive, definitely an Aussie through and through. But I think from a professional viewpoint, he writes beautiful books because you can read the book and you can actually just sit there and read it, and you don't feel like it's a massive chore to keep your eyelids open. It's not a book that you use for sleep inducing. And then we're going to have Malith from Colombo in Sri Lanka. He's a fellow of the Institute of Civil Engineers in both the UK and Sri Lanka. He's an associate member of the UK Chartered Institute of Arbitrators, member of the Dispute Resolution Board. He's a global expert on everything to do with FIDIC, and he's also a rare beast because he's a FIDIC accredited trainer, and his panel listings as a FIDIC trained adjudicator and a reviewer of FIDIC contracts. So we're incredibly lucky to be able to get Malith here today. He's also an expert in the field of engineering, and he's listed on the panel of arbitrators and adjudicators in the Institution of Engineers in Sri Lanka and associate consulting engineers in Sri Lanka. He's again renowned internationally, practiced in adjudication and all forms of dispute resolution, 35 years of project experience. I did start looking at the projects Malith had been involved with, and I was going to list some, but I bluntly gave up because the list is so long, I couldn't decide whether I'd have to give you the biggest or the most recent, and it just became all too confusing. So I thought instead I'd tell you just some of the countries he's worked in. So India, South Korea, Algeria, UAE, Eritrea, Mauritius, just to name a few. But it's his proactive and professional attitude, his high standards and business acumen that I think has made Malith a go-to person in terms of FIDIC. So I'm going to hand over now to Donald, and we will see if there's a delay. Oh, there you go. So our lovely pictures. So if, right, hand over to Donald now, and he's going to take you through, and then Malith, and I'll speak to you all again at the end.
Thank you very much for your kind introduction and the opportunity to speak tonight to this audience from around the world. Good evening, good afternoon, good morning to everybody. As Bill said, I'm speaking from Melbourne, Australia, and I should recognise the traditional owners of the land from which I speak and pay my respects to their elders, past and present. I'm trying to advance my slides, but don't appear to have the controls yet.
Yeah, you do if you just click again. One moment, Donald, I'll restart it for you. Try again.
This is the agenda for my brief talk tonight. Briefly about FIDIC contracts in general. We'll have a look at standard form contracts, particular conditions, and then I'm afraid you're going to get a bit of an advertisement for the book that Bill has mentioned, which in fact was published a year ago, The International Application of FIDIC Contracts, a Practical Guide. And extracted from that, we're going to talk about some jurisdiction-specific particular conditions in a number of different countries, and I'll finish up with a quick summary. Now, I'd like you to pay attention to the first of 6 photographs, because those of you who attended Bill's last webinar will recall seeing his various scenes from around the world. Well, I'm going to show you some photographs of construction sites I have visited, passed in various countries, and there's a little competition here. There are 6 photographs, each one is taken in a different country, and I'm offering a prize to the first person who can let me know which country each photograph comes from. And the prize will be an autographed copy of the FIDIC book that we're going to be talking about. So there is the first photograph, and I'll give you a chance to have a look at the others as we go through. Well, what are FIDIC contracts all about? FIDIC is the acronym for the French name for the International Federation of Consulting Engineers. It's an organisation that's set up to look after the professional interests of consulting engineers, not contractors, but it does publish the most widely used standard form contracts for construction that are used in many countries. They're drafted by a contracts committee and reviewed by friendly reviewers, amongst them Malith, as you've heard, from many different countries and jurisdictions. They have a common law heritage, but they're used in many common law and civil law jurisdictions. I think you'll see from the table I present later on, there's not a great deal that has to be done to use FIDIC contracts in various countries in the world. They're certainly the most widely used for international construction contracts. I think NEC are trying to catch up, but I think they've got a long way to go. The printed contracts that you buy from FIDIC have a series of notes. The majority of the book is comprised of the general conditions. There's then details of guidance for the preparation of particular conditions. There's annexes of various forms of securities, and there's example forms of letters and various agreements. So here is the second photograph, which I'll leave for a few seconds for you to try and work out which country this is in. A very nice bridge construction. Well, FIDIC standard form contracts, as I've indicated, are widely used in many countries. This is an indication of sales that were made, I think, in the year 2018. And as you can see, the majority or the largest number was sold in the UK, followed by South Africa. But there's quite a sweep of contracts, countries around the world that are using FIDIC standard forms. As I mentioned before, although FIDIC is an organisation set up to look after the interests of consulting engineers, it generates a great deal of income by the sale of its standard form contracts. These are, in fact, not the latest versions of all of these contracts, but you can see from the colours of the different contract forms why they're frequently referred to as the Rainbow Suite. I have a table of the various contracts that are in fact available, which shows the history of these. The red book, that is the book for construction that involves the employer's design, is the oldest, dates from 1957. I mentioned its common law heritage because it was based on the Institution of Civil Engineers contract at that time. So that red book went through 4 editions, the last one being 1987, and there were several supplements in the 1990s. That 1987 edition is in fact still being used in some countries in the world. In parallel with that was the yellow book, which originally was referred to mechanical and electrical plant. That also went through 3 different editions. But then there was, in 1999, major revisions and 3 contracts were issued: the red book, the yellow book and the silver book, now referred to as the first edition, the silver book being an EPC for EPC and turnkey projects. And each of those contracts, of course, was recently revised into a 2nd edition in 2017, and Nalith is going to talk about that a little bit more. In addition to those 3 Rainbow Suite books, we also have a variant of the red book, that is the so-called pink book, the Multilateral Development Bank edition. That's gone through 3 revisions, started in 2005, and the current edition is 2010. And then we've got various other forms, such as the green book for the short form contract for much smaller projects. We've got the design, build and operate contract, the gold book, the dredging and reclamation works, the blue-green book, which now is in its 2nd edition. And the most recent is the emerald book for underground works, typically tunnels. This colourful little slide just emphasises the significant differences between, first of all, the red, yellow and the silver books, and secondly, where changes have been made from the 99 edition to the 2017 edition. So the big distinction between the red book on the one hand and yellow and silver books on the other is who prepares the design. The red book is for design by employers, the yellow and silver books for design by the contractor. Both the red and the yellow books, we have the contract administered by the engineer, whereas the silver book, that is the EPC turnkey, the contract's administered by the employer's representative. One of the distinct changes made in going from the 99 to the 2017 editions is in the dispute board. Whilst the red book had a standing DAB, the yellow and the silver books only had an ad hoc DAB, that is a dispute board that was only appointed if there was a dispute. Each of those contracts now provides for a standing DAAB, a dispute avoidance and adjudication board. And then the other distinction between the red book and the yellow and the silver books is the method of payment. The red book is basically provides for the contractor to be paid on remeasurement based on a bill of quantities, whereas the other two books, their payment is to be made on a lump sum basis. So here is the third photograph of bridge construction, and I suspect this might be the most difficult of all, unless one of you or more of you visited this country during that construction a few years back. Well, looking at the particular conditions, and from now we'll talk about the 2017 editions, remembering that each of these three contracts, red, yellow and silver, all have the same structure and a very high degree of common clauses within them. And particular conditions now are split into two parts. Part A, the contract data, which had different names in 1999, but I think the contract data is by far the best name for it. And then part B is the special provisions. The contract data, as its name indicates, contains the data required to define the unique characteristics of the contract for the specific project. It's got all the standard things in it, the identity of the employer, the contractor, and various items of data, such as the time for completion, the details of payments to be made, etc. But our focus is on these special provisions that are necessary for the particular requirements of the works. And these may comprise either modifications to the general conditions or additional provisions. And those may be either necessary or desirable to comply or align with applicable law for the specific requirements of the site or the works, or for the employer's preferences. And here's a non-exhaustive list of applicable laws that may have a bearing on execution of a construction project and contract. First of all, we've got the governing or proper law of the contract. Then we've got laws of the site and the country. We might have law relating to the disposition of property in rem claims, procedural law that applies to any court proceedings, the law of the seat of arbitration, the substantive law that gives an arbitrator jurisdiction to determine a dispute instead of the courts. And each of these laws could well be from a different jurisdiction. We've heard about a recent Supreme Court case in the UK that dealt with the issue of the lex arbitri in a situation where the parties had not selected the governing or proper law of the contract. The two are not necessarily the same. And then we might have laws with extraterritorial reach, such as the Bribery Act from the UK. The applicable law can impact the operation of a contract in various ways. Mandatory law is what it says. It has to be complied with, and it'll override any contractual provisions. And irrespective of what the contract wording is, a construction contract has to be executed in accordance with the applicable laws. But we might have non-mandatory law, which typically provides default options if they're not covered or explicitly derogated from by the specific terms of the contract. So we now move on to the advertisement, if you like, for the book. that's already published, the International Application of Contracts, a Practical Guide. And the reason why I'm spending time on it is because without this book, we probably wouldn't have had this webinar tonight, because the material I'm going to talk about is drawn from the very hard work done by a number of authors from around the world. And this slide indicates in alphabetical order the jurisdictions that are covered in that first book and the authors who have written them. And you'll note down there that the Sri Lankan chapter, Malith Mendes is one of the 3 authors there, assisted by 2 colleagues. It's a very eclectic mix of jurisdictions, if you like. We've got jurisdictions from each continent, although we're really missing the North American continent, but we've got South America, Africa, Europe, Asia, and the Pacific. That book has been well accepted, and the publisher is quite keen that we extend this to ensure that we cover a number of jurisdictions that are not currently covered. So at this point, we're nearly at the stage of having a second book ready, which is devoted to the Asia Pacific. And I've listed there the various jurisdiction chapters. Clearly, a few of them are ones that have already been published in the existing book. But in addition to that, we have a chapter on the Emerald Book, which you'll recall is for underground works. And we've also got a chapter from the Japan International Cooperation Agency. They administer Japan's overseas development assistance and are very keen supporters of FIDIC contracts and users of FIDIC contracts. Now, each of those chapter authors was given a chapter template, which I'm pleased to say they all followed in quite close detail. And so that this is what the content of every chapter is. There's a brief outline of the legal environment. There's a discussion on what constraints there are in the governing law of a construction contract, if there are any formal requirements for a construction contract. And then this next one on what special provisions in the particular conditions are necessary for consistency with applicable laws. And those 3 subheadings there are the ones I'll briefly touch on in a moment. In addition to those special provisions that are necessary for consistency with applicable laws, we've also got a section on if there are particular goods that are desirable, not necessary, but desirable. And then we've got what I think are very useful tables on applicable legislation under those 3 headings, where the governing laws that of the jurisdiction, where the site or countries in the jurisdiction, or if the seat of the dispute determination is in the jurisdiction. And then there's another section that I think is particularly interesting, issues that a court or arbitrator may construe differently to that expected from the words of the contract because of local law or custom. The sort of things that you're not going to find from the contract itself. You're only going to find those sorts of things by talking to the appropriate people in the country itself. Now that chapter template, which I've indicated there, is being used with 2 significant additions for the new book on Asia Pacific, and the 2 additions are, first of all, a description of the construction industry in the jurisdiction, and secondly, what impact has COVID-19 had on the what impact has it had on either the performance of a construction project or the operation of a construction contract. here, I think, is the fifth photograph of a bridge construction in a country. So I prepared 3 tables and extracted what particular conditions are necessary in these jurisdictions. So the first table is where FIDIC general conditions are incompatible or inconsistent with the governing law of the contract. Now, we don't have time to discuss any of these tonight, but handout is going to be available from Barton Legal that in fact provides for each of those headings a little paragraph on what it is that is actually required in the particular jurisdiction. It won't save you the expense of consulting an appropriate construction lawyer if you're working in that jurisdiction, because the one thing that the book has never set out to do is try and provide the actual wording of particular conditions. That is clearly something that needs to be done based on the particular circumstances and the facts of the individual project. But one thing that you can note here, we have 18 jurisdictions covered in the book, and there are only, if you count them up, I think 11 jurisdictions listed on this table, which means that there are 7 jurisdictions in which the authors have said there is no requirement for particular conditions to make FIDIC general conditions consistent with the governing law of the contract. The second, much shorter table we have is where FIDIC general conditions are incompatible or inconsistent with the laws of the site or country. And we only have 4 countries listed here. And for the other 14 jurisdictions, there are no particular conditions necessary for consistency with the local laws of the site or country. And then the final table here is if general conditions are incompatible, inconsistent with the laws of the seat of the arbitration or relevant laws on dispute determination. And as you can see, there are only 2 countries listed there. I'd like to acknowledge the hard work that's done by all the chapter authors. The book clearly wouldn't have been possible without that. And you'll see if you get the handout that has a little bit more detail on each of these tables, there's a citation for the individual chapter from which I've drawn the book, the material in those tables. We've come to my very brief final comments, and I'll leave that photograph up there for a few moments, the final photograph for you to contemplate. So in summary, FIDIC contracts are the most widely used international standard form contracts. The drafting has extensive international input. They're suitable for both common law and civil law jurisdictions. And I think you can see from the tables I put up that the particular conditions essential for conformity with local laws are quite limited in number. And I've noted there, JICA uses the FIDIC Pink Book, that is the multilateral development book variant of the Red Book, and the 99 Yellow Book in its standard bidding documents. And FIDIC contracts are also implemented by the World Bank and other MDBs in their standard procurement documents. In my view, FIDIC contracts represent the closest to an international norm construction contract that, if appropriately followed, will lead to best practice construction contracting. Thank you for your kind attention, and Melith will now take over and tell us in some detail what the changes have been made from the 99 to the 2017 versions of the Rainbow Suite.
Right. Let's see whether I can move on.
So, hopefully, Melith, you're there and you can.
Yeah, let me see whether I can move.
There you go.
Right, there you go. Okay. Thank you very much, Donald, and thank you, Bill, for the introduction. I hope all of you can hear me well. It's about 6 o'clock in the afternoon, evening in Sri Lanka. I will talk something about the changes that have happened in the 2017 edition FIDIC contracts. What are the changes from 1999 edition? Now I'm a FIDIC certified trainer, and I also was a reviewer of the 2017 contract. So I was involved in the 2017 contracts, the drafting, the comments, the reviews from an earlier stage than long before it was published. So what I'll try to explain to you is what are the top changes that you will most likely expect, and what are the things you should know before you actually come across it. It's not very much used in the developing part of the world, but definitely some are being used in Europe. Last week I found out that the 2017 contract is going to be used for a project in the Maldives, so we can see some progress, some move in developing countries to use the new contracts. Let me move on. Now, as you know, the 1999 edition has been around for 18 years. Since 1999, of course, there have been a lot of changes in construction, in digital usage of digital technology in construction, in digital communication. So one of the reasons for the 2017 contracts was to understand that and bring that into the modern day construction technology, as well as the information technology that's available. And as you know, 1999 contracts have quite a lot of gray areas, and I would say dead ends, not many, but there were areas where we were not too sure what do we do next, and a lot of places where what if one party does not do something, then what do you do? It was left to for us to decide what to do. Quite a bit of legalese, legal language was used, so that's one of the things that was addressed in the new contracts, and address criticism that has happened over the last 18 years on the 1999 contracts. So those are the things that was looked at. One, so 2017 contracts, I would say, are a lot more procedural and a lot more prescriptive. That was mainly because of trying to reduce areas where a contract user will not know what to do next, to try and give a procedure on what should be done. These came about from usage in contracts where the next step was not too sure. A lot more detail goes into a lot more detail on what needs to be done. There are several instances where notices have been given that was not there in the 1999 contracts. And all clauses have been changed. All the clauses are changed, some more than the others, but all the clauses are changed, and they have increased in what I would say is in size. Now, instead of the 20 clauses that were there in the 1999 contracts, now you have 21 clauses. And that's mostly because the claims and the disputes have been separated out. Claims are not necessarily disputes. So I guess that was one of the reasons. Of course, the claim procedure is a lot more detailed now and more prescriptive and procedural. So the contracts have nearly twice the number of pages. They're known to be weighing 1 kilogram, each one of them. So the three contracts, the red, yellow, and the silver, are known as also as a 3 kilogram suite. And of course, the definitions are also in alphabetical order. So that is one of the confusions in the 1999. Unless you knew where a term was classified under which group, it was difficult to find. So now the new 2017 contracts will have the definitions in alphabetical order, and there are a lot more definitions. So almost every lot more terms are defined, and one of the most prominent is notices. Notice in the 1999 contracts was not defined, but in the 2017 it's defined. Then also there's an advisory notes to users on BIM, building information modeling, on how to incorporate that into the contract. And of course, as Donald also said, the particular conditions of contract. Now, as you know, the 1999 contracts had, two of them had appendix to tender. Now we have been split into two parts, part A, contract data, and part B, special provisions. Now, I believe that some of this came from the so-called MDB harmonized version, the so-called pink book, because that already had practiced some of these things, like the particular conditions of contract being split into two parts, and so many other things, like where the employer also has a time bar for giving notices and submitting claims, which are now being introduced into the 2017 contract. So some of the aspects, features of the pink book have come into the 2017 contract. Those of you who have used it in MDB supported projects will already be a bit more familiar with that. Then of course, force majeure is now termed as exceptional risk, and I will talk about it more in later. So one of the things is to make it more in the English language rather than have words that somebody who is working on a project may not understand what it is. Right. So in 2017, FIDIC published a new editions. And FIDIC, as you know, are the most widely used in the world, as Donald also explained. And these new contracts will have an impact on the construction industry worldwide. So here we will discuss the top changes in the new editions. So as I said, almost every clause has been changed, but the risk and responsibility allocations remain the same as of 1999. So it's very important that you know that the allocations of risk and responsibility remain the same as in 1999 contracts. But the engineer's role is a lot more reinforced in the administration of the project, and greater procedural detail and time limits for carrying out all the functions that an engineer has, playing the role of the engineer in the contract. So engineer has a much wider, much more, what shall I say, committed role in the new contracts. Right. So similar to the 1999 contracts, the risk allocation stays the same. So as you can see from here, the red book, the yellow book, and the silver book, which are the three main books, the risk and responsibility allocation, as you know, in the red book is most relies to the employer. And then of course in the yellow book, with the detailed design and quantities responsibility moving to the contractor. And in the silver book, there's a lot more risk and responsibility that is transferred on to the contract in the silver book. So this risk allocation stays the same in the new editions. Now notices. One of the most prominent changes in the 2017 contract is the requirement for notice. There are some 80 places where there's a requirement for notice, and it's defined now with a capital N, starts the capital N and defined, and has to be distinguished from other forms of communication. In addition to that, there's notice of dissatisfaction also, NOD, which are now even required when a party is dissatisfied with the engineer's determination. So that also comes in as something new. But notices, the requirement for notices and that it being distinguished from other forms of communication is very prominent in the new 2017 contracts. Profit, again here, possibly comes from the pink book, with using the pink book. It says that in case of relief events, a contract will be entitled to 5% profit, unless otherwise stated. Of course, unless otherwise stated. And in the 1999 editions, there was no stated figure. So this goes into general conditions, the profit amount, unless otherwise stated in the contract data. And the 2017 editions also specifically entitles the contract to any loss of profit or other losses and damages suffered for variations and for termination for convenience. So this loss of profit and other losses and damages, which was not clearly defined in the 1999 contracts, now comes in the 2017. Possibly another something that is quite a change from the 1999 contracts. So what I will do is also look at clause 3.7, where the engineer's role is a lot more prominent. Now this was 3.5 in the 1999 contracts, the agreement or determination by the engineer. Now it's 3.7 in the red book and the yellow book, but 3.5, subclause 3.5 in the silver book, employer's administration. Now it says very clearly here that an engineer, when carrying out duties under this subclause, shall act neutrally between the parties and shall not be deemed to act for the employee, it says, at the start of the subclause. So it makes it very explicit that the engineer has to act neutrally between the parties here, then under this subclause. So this is something new in the 2017 contracts. And it gives a whole procedure on how an engineer's determination has to be done. And I give you here some of the scenarios in which an engineer's determination is processed through. Now, this all comes in clause 20, but the within the clause 20 of the claims, but in 3.7, you find the full procedure of what the engineer should do. And it's a lot more detailed than the 1999 contracts. Now, as you can see from this graphic here, engineer starts performing duties under subclause 3.7. If there's a parties reach agreement within 42 days with consultations by the engineer, then the engineer gives a notice of agreement under subclause 3.7.1. But within 14 days, a notice of error can be given by a party or the engineer himself. Let's say he has made an error, he can give within 14 days a notice of error. So there's 42 days for the engineer to give a notice of agreement if the parties agree on the claim. And then of course within 7 days, if any party is dissatisfied, engineer gives a notice of corrected determination. So this is quite a change from 1999, because it just said the 1999 contracts, engineer either approves or disapproves or partly disapproves the claim. And then of course it said that contractor can go and ask for a formal determination on top of that. But here, engineer definitely has to make a notice of agreement or determination has to be done. Now, this applies to both parties. Whoever puts a claim, it's an employer's claim or a contractor's claim. Earlier, the process would have been only for a contractor's claim. Engineer's employer's claim that came under subclause 2.3, and there was no proper procedure as such. The agreement is reached within 42 days, error found in the engineer's agreement and corrected. So that is one scenario. Agreement is reached, but an error is found. But if not, no error, then of course, engineer's notice of agreement will stand as it is without any error. Then another scenario in which the parties early advise that agreement cannot be reached, and so engineer's determination is necessary, no error in the engineer's determination. So in which case, engineer starts performing duties, he makes consultation over 42 days, but the parties advise that agreement cannot be reached. Then the engineer has 42 days to make a notice of determination. Of course, if there's no notice of error, then within 14 days, then there's no reason to give a engineer's notice of corrected determination. Then, but of course, it allows for, as you know, allows for everything where within 28 days, a notice of dissatisfaction can be given for this engineer's determination. Now, this notice of dissatisfaction is something new in 2017 contracts. It was not there in the 1999. You don't need to give a notice of dissatisfaction. You can make your referral to the DB or DAB, the Adjudication Board. Let's look at another scenario. Here, no agreement within 42 days. Engineer determines within 42 days. Error found in the engineer's determination corrected. This is, of course, the longer where there are consultations, but no agreement can be reached. Then engineer makes a notice of determination. And then, of course, there can be notice of error. And within 7 days, engineer can issue a notice of corrected determination. And again, allows 28 days for a party to give a notice of dissatisfaction. So there are many routes to take on the process, but this process has to be done. So engineer has a much bigger role to play in the 2017 contracts as far as determinations are concerned and processing of claims are concerned. Then again, the changes in the design responsibility. In the yellow book, is similar to what was there in the 1999. But again, on the yellow book, it says engineer to check if there's a variation claim by the contractor, saying there's an error in the employer's requirements, any mistake, engineer to check that an experienced contractor would not have found the error in 42 days. So if he makes a determination that the contractor should have found this error within 42 days, an experienced contractor would have, then of course it may not be a variation. So this is something new in the 2017 contract. So again, applies even after the contractor has produced a detailed design, he finds a variation, if he finds a mistake in the employee's requirement, again, engineer has to determine whether an experienced contractor would have found the error within 42 days. So that's something new in the 2017 contracts compared to the 1999 contracts. And advance warning. We have talked about this in the 1999 contracts, practiced by some projects, in some projects. Now, clearly, the 2017 contracts talks about advance warning under subclause 8.4. So for the first time, I have said red book, but all the books it's there. Introduces advance warning provisions, which require each party to advise the other in advance of a known or probable future events which may adversely affect the work of the contractor's personnel, adversely affect the performance of the works when completed, increase the contract price, or delay the execution of the works or a section. So advance warning provision now comes in the 2017 contracts. And as you can see, it's subclause 8.4, which used to be the extension of time subclause in the 1999 contracts. The extension of time has been moved to 8.5. However, there's no time limit for giving an advance warning, nor is there any explicit sanction for failing to do so. So there's no time limit for advance warning. And if the contractor or the employer does not give any advance warning, and it can be any party as well, that means it could be the engineer as well, there's no sanction for failing to do so. There's no penalty for failing to do so. Then 8.5 extension of time has a bit more explicit provisions on the EOT, extension of time. The four important changes I would say are if there's a variation, then of course a separate notice does not have to be given for an EOT for variation. Instruction is issued. So the contract is not required to give a separate notice of a claim for an EOT for a delay caused by a variation. So that is there in the 2017 contracts. And again, about exceptionally adverse climatic conditions, it qualifies it by saying unforeseeable having regard to climatic data. But again, I must say, the engineer will have a lot of interpretation of what this climate data and what are the limits that might have been exceeded for it to be considered an exceptional adverse climatic condition. But this qualification has been put in the EOT provision 8. Subclause 8.5. Then also any increase of estimated quantity. There's an explicit entitlement to an EOT if it goes more than 10%, an estimated quantity. Then of course also it says about concurrent delay. Concurrent delay, it says that parties may need to adapt provisions in respect of concurrent delay, that is proportioning of costs, etc. And it also talks about in the guidance on the preparation of particular conditions, it also talks about the Society of Construction Laws delay and disruption protocol. It mentions it, says it's the most international widely used. So maybe pointing the way towards what kind of protocol principles we should adapt in analysis of delay and extension of time in the contracts. Then exceptional events, force majeure is now called the exceptional events, but the risk allocation remains the same. So there's not much change there other than it being called the exceptional events. Then of course claims. Claims, the procedure is a lot more detailed and includes notices that the engineer may have to give, a lot more, and also handles the employer's claims and contractors' claims in the same clause. And it says provisions related to claims and disputes have been separated and redrafted substantially. Clause 20 sets out a procedure for employer's claims. Additional payment from the contractor or reduction in the contract price. Also handles the contractor's claims and either party for another entitlement or relief against the other. So that is also there. It might be, for example, some things like establishing what is the date of completion. So something that's other than maybe some claim, but establishing some entitlement or relief. So that is also now included in subclause 20. So that in addition to a claim for money or time. The existing 28-day time requirement for notifying claims now applies to the employer as well. So the employer also has a time bar of 28 days to give a notice of a possible delay or claim. And the old 42-day time frame for the fully detailed claim has been increased to 84 days. So the 42 days that we were used to for a fully detailed claim increased to 84, mostly because over the years it was realized that 42 days is not adequate time for a contractor to give a fully detailed claim, and usually partial detailed claims are received, and that 84 days might be a better time frame in which to submit the fully detailed claim. So that's another change that is there. Again here, for a short event, for a notice, then of course a fully detailed claim in 84 days compared to the 1999 contracts where it was only 42 days. But then it's very clear that the engineer shall proceed under subclause 3.7. Earlier it was 42 days, and the engineer shall approve or disapprove in the 1999 contracts. But here, the whole procedure has to be under subclause 3.7, and he has to go through that procedure which is specified in the contract. Even for a continuing event, same thing again, 84 days to submit the detailed claim. Again, the engineer has to go through the procedure given in 3.7. So there's no getting away from that. Right, then sequence on times for completion, tests on completion. So if a contractor wants to apply for a taking over certificate, what is new here is the test program. And this test program for any testing on completion has to be given 42 days prior to the date that the testing will start. So that's something new, which is not there in the 1999 contracts, this test program. Not much change in the sequence of payment events. Stays the same as of the 1999 contracts. I think quite a lot of you may be familiar with this. Let me go on, but there are some qualifying statements there as far as the final payment is concerned. It says if the contractor has not submitted a draft final statement, as you know, a draft final statement is submitted, and then the engineer checks and the contractor and engineer agree on it, but he has not submitted. Engineer requests to do so, but if not within 28 days, the engineer issues a final payment certificate for an amount he considers due. So there's this tendency in the 2017 contracts where earlier it had come to a dead end without the draft final statement being submitted by the contractor and the engineer not being able to do anything. Now he can issue a final payment certificate for an amount he considers due. So it's a lot more explicit here. And then also if the contract has submitted a partially agreed final statement or no partially agreed final statement has been submitted, but to the extent that the draft final statement submitted by the contract is deemed by the engineer to be a partially agreed final statement, the engineer shall issue an IPC. So there are several scenarios here where the engineer can go ahead and issue a final payment certificate or an interim payment certificate, which probably would have been seen as what do we do from now, from this version, what do we do now in the 1999 contract. So there's a lot more detail on the final statement and the draft final statement and such partially agreed final statements. Then of course something new, as Donald also spoke about, the DAB, the Dispute Avoidance and Adjudication Board. So there's a lot more focus on the dispute avoidance, and all the, as you know, all the contracts have standing boards and a dispute avoidance role. So that's good, considering the success of the dispute boards and standing dispute boards in solving disputes in contracts and projects, and not escalating to the next tier in the dispute resolution process. Now, usual DAB members are appointed within 28 days after the contract receives a letter of acceptance, unless otherwise agreed. But resignation, termination, and new appointments have a lot more detailed procedure than before. Then there's a sub-clause allocated to informal assistance that the parties may require, and that is also provided for within the clause 21, which now deals with dispute resolution, and it's a new clause in the 2017 contracts, which is there as part of 20 in the earlier 99 contracts, but is now separated out in the 2017. Then there are changes somewhat to the, I would say, the legal part of things, limitation on liability. Earlier, delay damages and any damages due to termination were separate so-called liabilities, as in limits. Delay damages had their own limit, but now it has been brought under the limitation on liability, including the delay damages within part of that. Of course, the 2017 contracts also talks about gross negligence, in which case there's no limitation on liability. But as you know, different jurisdictions can have different approaches to gross negligence. So that might be a concern in use in the 2017 contract. Termination for employees' convenience. This grants a contract with loss of profit, which was not very clear earlier. And employees now enter to give the work to another contractor after payment under contract to the contract under subclause 15.6. Now earlier in the 1999 contract said the employer terminates for his convenience. He will not do that to give to another contractor. But here it says in the 2017, he can give the work to another contractor if payment to the contract is made under subclause 15.6. Then regarding subcontracts, as you know, nominated subcontracts were a separate clause in the 1999 contracts. Here it says subclause 5 is subcontracting, and that includes nominated subcontractors as well as any other subcontractors within one clause. So that's another change that is there in the 2017 contracts. Expanded obligations to indemnify both for the employer and the contract in the new contracts. There's a lot more detailed and a lot more wider. Also, I will say that the new additions may be considered more rigid and prescriptive than the 99 contracts additions, but leads to contracts being double the length. However, there's this deeming provision that is there everywhere. Hence, engineers, employees, and contracts required to ensure they comply with wide use of the deeming provision. They fail to do so. So the deeming provision is used quite a lot. I wouldn't know how many places, but quite a lot deeming where it's deemed something has been done or happened if any party fails to meet their obligations. Then, of course, the FIDIC Golden Principles were also published by FIDIC somewhere with the 2017 contracts, which sets out what replacements and changes should not be introduced to contracts while the particular conditions that the contract agreement, final contract or agreement no longer represents the FIDIC principle. So that is also important, the FIDIC golden principles came out almost at the same time, which says there are certain things in the golden principles like time allocated for the parties to meet their obligations, allocation or risk, drafting, clear drafting, things like that, which are 5 golden principles, which were also published together with the 2017 contracts to ensure or to guide employers and contractors on what should not be changed so that it's no longer represents a FIDIC contract. Then of course, based on the 2017 Yellow Book, the Underground Works contract of 2019, the Emerald Book also is available now. In fact, I had to lecture on this even before I lectured on the 2017 Yellow Book a few months ago, which caters for any tunneling or creation of underground space, and particularly quite different from most of the FIDIC contracts, because some of the items of work stay as lump sum items, but others are remeasurable. Especially the excavation and lining works are remeasurable. So maybe most of it was developed together with the International Tunneling Association, but based on the 2017 Yellow Book. So that's another development that has happened with the 2017 contracts. Okay, thank you. I'll be willing to answer any questions. This is my Gmail address. Thank you very much.
Oh, that's fantastic. Thank you very much, Malith. Hopefully you can all hear me, and I think Rachel's going to take back control. So, as I've put in the chat, now is your opportunity to put in some questions for Malith and Donald. Don't be shy. You don't often get the chance to ask this sort of quality of speaker. Whilst you're thinking about that, and I will reference this again, please note in your diary that the 17th of December, we're doing a quiz rather than a webinar, but it'll be a quiz. 21st of January, we have our next one, and that will be featuring Bill Howard, who's the president of FIDIC, who's going to look back at 2020 and forward to 21. 18th of February, David Sears, QC, and also I hope that we'll have somebody from the Dispute Resolution Foundation as well. 25th of March, Gordon Nardell. So you can see that the quality of speakers and the range just continues. There are some other points to note. The quiz next month, there will be prizes. When you register next month, you'll be asked to put in your address. You're being asked to put in your address because everybody who registers will send to you a Yorkshire calendar for next year, which is obviously absolutely guaranteed to bring you good luck, because Yorkshire is obviously one of the best places to be. What else am I going to say? Right, we'll come on to questions. I would also remind you of Donald's challenge to you all. If you can identify all the pictures, then I think Donald will confirm that the prize is a copy of your book. Is that right, Donald?
That's correct. And just so that you're not overtaxed with a flood of work to do, to pass on to me, perhaps if people could email me their entries into this competition, and I will inform you before the next webinar you're conducting of who the lucky winner is.
And can I say to everybody that I had the very good fortune to review Donald's book, and it is really good. There are, as he set out, there's chapters on all the countries, but it really just help you to understand the application of the particular forms to the different jurisdictions and the way they're looked at. There's a huge amount of information because you've got that very individual approach by chapter. So I have made a note of a couple of questions. So Abdullah, hi Abdullah from Turkey, asked about the Yellow Book and the question of why does responsibility for ground, Donald and Malith, lie with the employer, even though design is with the contractor? There have been some suggestions for answers, including my own, but I'm interested to hear what Malith and Donald make of that. So who wants that one, Malith or Donald? Donald.
Malith, you want to take that?
Do you want me to repeat the question, Malith? Or?
Yes, go ahead.
So Abdul is saying basically in the yellow book, it leaves the responsibility for ground conditions with the employer, even though the design responsibility is moved to the contractor. Do you know why that split was made?
I think it comes from the fact that a tenderer or a contractor, prospective contractor, will have a few weeks to inspect the site, while the employer has been planning his project for maybe a year or so or more, and has a better knowledge of the ground conditions and has been able to find enough data. So in the yellow book, similar to the emerald book, the emerald book of course has a geotechnical baseline report under which if it goes outside that, the ground conditions, the contract has a right to claim for extra money and time based on the fact that that was supposed to be the baseline ground condition that he was supposed to encounter. Now, I think similarly, it's in the yellow book. Although contractor does a detailed design, the ground condition information will be obtained from the employer, and what is based on the information given to the contractor. Now, under the subclause that deals with unforeseen ground conditions or unforeseen physical conditions, if the contractor can prove that an experienced contractor could not have foreseen these ground conditions, he can claim for more money and time, but he must be able to prove that it was unforeseen physical conditions that he has met. It can be, geotechnical considerations, it can be physical, it could be man-made, it could be hydrological. That's something he could not have foreseen. So that's where a contractor is able to claim for extra time and money based on the fact that he could not have foreseen based on the information that was made available to him.
Okay, a very comprehensive answer, and from the solicitor's point of view, it obviously depending on whom I'm acting for, my experience is my clients always want to shift everything onto the contractor, which is fine by me, even when I'm acting for them. But I do believe that should be on the basis of full disclosure. I see too many instances where it comes to me after the event where the situation that Malith describes, one party's had information about the site for a long time, it's passed over to a contractor who has incomplete information, doesn't obtain necessary information from the employer or warranties or whatever, and is left holding the proverbial baby. If you're a contractor, it's very important that you get at least a warranty, but you need to look at what was the form of appointment. There's a lot of ground investigation work that is done on, in my view, very poor appointments that don't provide for a degree of liability for that consultant, or it's limited on a cap, on a multiplication of fees. And ground is frequently, when there are problems that occur, quite often later in the contract, particularly when there's piling and other issues, or where a site is divided into parts, and it's not enough time is spent in that preparation, I think, by contractors who are very keen to get onto site. Okay, we have another question, so I think it's only fair that this one goes to you, Donald. So Lahiru asks, advance warning under clause 8.4 of the 2017. It's really like a sort of mastermind quiz. Obviously, you can just imagine that clause in front of you. But basically, the question is, in relation to advance warning, I think he's saying the clause refers to works or sections, but doesn't refer to part. Is there any, in your view, any sort of distinction to be made for why early warning it's only saying works or sections, but doesn't use the word part.
Well, I suspect that's merely a quirk of drafting, because the intent of an early warning is to provide the other party with notification of a situation that is going to change in some way the works. And I don't think there's any intention to confine that early warning in any way. It's really all part of trying to promote proper communication between the parties and cooperation in the execution of the works. I don't think there's any intent to limit that early warning to the exact provisions. I think it's a much more general requirement that if you're aware of anything that can impact progress, cost, time, whatever, then you're obligated to raise it with the other party.
Okay, so
can I add one to that? That's
yep.
Because FIDIC contracts defines the works and defines a section. It does not define a part within the contract. So a part can be, which is a part of a section, which can be taken over by the employer, but still it's not defined in the contract. It's simply that. So in the contract, a section is defined and the works is defined, but a part is not defined.
Okay, so I think what you're saying is lawyers didn't draft enough. I agree with what you say, but again, I would say to you all, and anybody who, so Donald, Malith, put your hands over your ears now, anyone involved with drafting FIDIC, of course, we solicitors and lawyers, we're just not happy with what you give us. So whatever you give us, I'm going to start playing with it. I will add in, if I think necessary, a definition of part. I will add in more definitions. I love definitions. I think definitions can make or break your contract by being more specific and enabling you to better describe works and notices. So I agree with both your answers. I would say that the early warning still applies. If you think the works are going to be in some way necessary to be described in more than works or sections, then, you know, as my kids would say to me, duh, you know, let's think about the drafting early on. Okay, we've got some other good questions. So, trying to keep up with the chat. So, an almost ready building before completion is being kept pending due to force majeure. What will be the implications on defects notification period, and why should the contractor be blamed? So I presume that's saying that the building is almost at takeover, but presumably the employer is saying they don't want to take it over, and therefore there's a tussle there between contractor and employer. So Malith, is that a case of until a building is actually certified by an engineer as complete, it's not complete?
This definition of completion is basically when the works are in a position where it can be used by the employer. It doesn't mean that there's outstanding, small outstanding work or there are defects, but it is in a position where it can be used by the employer. So if the employer can put it to use despite the force majeure, then it basically can be deemed taken over or it's ready for taking over. So I don't see it'll be being unfair to the contractor if the employer refuses to take over because of a force majeure event.
Okay, again, we'd have to bear in mind that economic flow is often a decider of whether an employer wants to take over a plant or whether they want to use the economic or other factors, a pandemic, as an excuse to avoid the responsibility of taking over a building. But as Malith says, you then have to look at, is any part of that building or plant being put into use? Okay, another question. Look, I speak English, so when it comes to people's names, I can only grovelingly apologise. I'm good with David's and Gerard's, but Rajina Thanu has said, is acceptance of voluntary administration of the contractor by the employer tantamount to a waiver of liquidated damages being levied? Donald. I'll tell you what, it's great just being able to pass these questions to someone else. I could answer it, of course.
Would you
read that one again?
Yeah.
Right. Basically, the contractor is insolvent, and so, but they've gone into, here it's described as voluntary administration. That's a miss, but say they're insolvent. So in a situation where the employer says, okay, you're insolvent, I'll accept that, have they waived entitlement to then claim against that insolvent company delay damages?
Well, I would think that any accrued rights up to the point of accepting termination will still be available to be pursued. Similarly, the rights that exist after termination of the contract. I mean, FIDIC is quite detailed in terms of how these things are dealt with, but the issue of becomes much more complicated because the construction has to be completed by another contractor, and until all that work's done, the employer won't know the extent of the damages that it suffered. So I don't think in that situation there's any waiver of legal rights. It's one area where you would have to look quite closely at the local law that applies there, because this comes down to some of the rights will depend on what the local law on liquidation and insolvency is.
Okay, and I think you're absolutely right, Donald. I think your answer is correct. I don't see that accrued rights are lost. I'd also remind people that, of course, insolvency, when it's provided for in a contract, which of course it is in FIDIC, is not going to be in any shape or form a breach of contract, because it is so provided for in the contract. And subject to how you've played around with the insolvency provisions, come back to lawyers meddling with the contract, you will have those accrued rights, and you will be taking into account the costs that you will incur for completion of that project, which may be other than simply the completion of the works, depending on how orderly or disorderly the departure from site of the particular contractor was. Okay, another question. Ignacio, I hope I pronounced your name right. How do I convince a reluctant engineer to pay for transport? Well, Malith. Actually, if anyone else has got an answer, you can all jump in, but I think we do need to put Malith and Donald on the spot. How would you get an engineer, how would you persuade an engineer, Malith, encourage them to consider transport a recoverable cost?
Well, it depends on what transport is. I mean, if it was transport that was within the contract, then of course he will get paid for it. It is obviously this is something extra and over above what is allowed in the contract. It might have reasons. I mean, it might be reasons due to COVID that they have to be transported separately. In which case, it's a change of law, which under 13.7, a contractor will have a right to claim costs. So it depends on what the circumstances are, and the engineer will have to be reasonable. Why
Okay.
the reasons for this extra cost of transport is.
Can I
Okay,
add
a
to
good
that?
answer.
I'd like to add to that a little bit of advice that's I use in many presentations, which I usually put up on the whiteboard. The acronym RTFC, read the final contract, because like most other things, the entitlement will be there in black and white in the contract. And
Well, I'm sorry, Donald. But you are now going completely off piste, asking people to read the contract. I mean, there are some I can't be the only Hungarian deprived lawyer on this call. I know there are some others, and of course, if all of you start reading the contract, then what am I going to do? That's just not really playing the game. Obviously, the advice is to read the contract. But if any of you should happen to just fancy entering into a nice big contract without reading it at all, that would be fine. If you could just get a couple of months into the works and then call me, that would be marvelous. So just seeing if there's any more. Yes, a suggestion that you hire a lawyer. Yes, I think that's always a good idea. Dealt with that one. Donald's plugged his book again in case you haven't seen, one for Asia Pacific coming out next year. Oh, here's a good one. How to quantify the adverse climate conditions if there is no mean value of rainfall in the contract, or how to interpret it. Are we just going back to if you haven't defined it to start with? Malith?
Yes.
What do you do with, so adverse conditions?
Yeah, well, the general conditions of contract usually defines what the 2017 contracts defines. It was a lot more looser in the 1999 contracts. That it's unusual when considering the historical data, right? But it still leaves a lot of interpretation by the engineer whether it was unusual. So that's where it stands at the moment. So most contracts will define what is what they consider now. Let's say in Sri Lanka, they have so many millimeters of rain per day. More than exceeds that, it becomes a day you can claim as extension of time. So contracts, the engineers and consultants will define what is unusual. But when it comes to with the global warming, is that there's although it might not exceed a certain number of millimeters of, let's say, rain, there's intermittent rain at certain places where there's rain in the morning, again rain in the afternoon, again there's a break, and that becomes disruption in a contract. So then it might have to be a disruption claim rather than extension of time claim. So engineer will have to do a lot of interpretation of what is unusual climatic conditions or exceptionally adverse climatic conditions. So the contract will, a good engineer will interpret that and let the contractor know what is considered unusual.
And as Georgiana has pointed out, many civil law jurisdictions will actually define adverse weather conditions. So again, it comes back to applicable law of the country. There may be statutory provisions, civil provisions that will govern the terms of the contract that you're working on because of where you're working. So looking down or up, I mean, just while I'm skimming through the, see if I've missed any questions. Malith, I mean, and Donald, how widely do you think people have now moved from the 1999 versions to the 2017 versions?
I suspect not very quickly. I don't know firsthand, but just knowing the reluctance of organisations to move from what's known. To give one example that I am aware of, I mentioned JICA, the Japan International Cooperation Agency. They use the 99 Yellow Book in their procurement documents. They've looked at 2017 and decided for various reasons not to use it at this point. So they're sticking with 99, and in addition, they're also sticking with the Pink Book, that is the MDB version of the 99 Red Book. So conversely, the World Bank, I think, has moved to the 2017 editions.
May I add something there? I believe, as you know, there's a kind of a lag period within which 2017 there was introduction, and probably 1 year or so for consultants to understand the 2017 contract and then actually get put into tenders, from tenders to tender procedure. So it will take a bit of time. So I think right now more and more 2017 contracts are being used, but also understand that it's a lot more procedural and prescriptive, and therefore there's a lot more commitment from the parties to adhere to the procedure and prescriptions given there. But when it comes to MDBs, from what I understand, the latest news is that they will adapt the 2017 contracts, but will have what they require for the particular bank different to the Pink Book. They will have what they require in the particular conditions. So for each bank, it will be a different particular condition. So that's what the understanding is now will be for adaptation by the MDBs of the 2017 contracts.
Okay, very good. Well, there aren't any more questions at the moment. So I'll make another plug for, as I say, next month, 17th December, there's a quiz. There are prizes for the winners, and I promise to ship it's going to be a little basket of goodies, of Yorkshire goodies. I promise to ship those anywhere in this country or the world to get them. In January, so we've got Bill Howard, who's the president of FIDIC, is going to be talking. I've also asked, but she hasn't responded yet, Claudia Solomon, who's the new president of the International Court of Arbitration, and I'm also hoping that we will have a very senior person from the English judiciary. So the aim of that is to give us all a sort of a feedback on what they've seen from this, really exciting, wonderful year that we've all enjoyed, 2020, and also what they see as developing next year. And the reason I think that's useful to everybody, because I think it's useful to know what the people at the top have of their views, because that's going to impact on all of us coming down. And it's also very interesting issues to discuss with your clients and other contacts. And it will help us certainly to be as up to date as possible. David Sears QC will be speaking in February. And there we're hoping to have the balance between adjudication and the balance with the Dispute Resolution Board Foundation. And then in March, Gordon Nardell, where we'll look at certain specific issues in relation to termination in FIDIC. Can I give a plug and a thanks to Rachel and virtual assistant who have managed this webinar for us. I can highly recommend her company in terms of any of you are going to be running a trial or a virtual hearing. We use her company all the time and it is fantastic. And despite what people say, at Zoom, we held the first ever virtual trial in May in English history, and that was fully secure. We had up to 50 people attending and the press, and the court was very happy. So well worth speaking to Rachel, but equally, if you're just having a Christmas do, get in touch with her. For the quiz, you will need your phone, because there's an app that you'll have to just go on your phone on Safari, you tap on the app and then the questions appear and you can just tap in the answer, so that people like me can't cheat. And I say yes, when you register next time, you'll be asked to put your address, because if I don't have your address, I can't send you our amazing Yorkshire calendar. And I can see Adrian, that's one of the things he'd really love. And on your wall, who wouldn't want a beautiful picture of the Yorkshire countryside? I accept that if you're in Nepal or Mauritius, it's a tough competition. So finally, my thanks again to Donald and to Malith. I hope everyone has enjoyed this webinar. We've certainly represented a big chunk of the world in having something like 53 countries here. You will get the email tomorrow to be able to download their presentation and handouts. They also have their contact details, so do get in touch with Donald if you want to win a copy of his book, which is, you know, it's a chunky book, and when I reviewed it, I said, if anybody is going to be using FIDIC, this is the first book that you should look at to get your head around what you need to do. It really is a good book. So you need to email him. If you've got any questions, email Malith and Donald. If you have any other issues, let me know. Equally, I'm more than happy to put anybody in touch with anybody else who attends the webinar. So if you've seen somebody and you think, oh, I'd really like to get in touch, let me know. I'm not possessive about these things. I'm a massive believer in collaboration and sharing information. Again, I'd like to ask if anybody has any specific requests for anything to be in a webinar going forward, let me know. We've lined up our speakers to pretty much next June, but we can add in issues, so do let me know. If any of you would like to speak at one of the webinars, let me know. And we send out a regular newsletter. I would genuinely love to any of you to offer to provide articles that you think would be of interest to other people. My only requirements are, if you're going to write an article, please think about actually putting in real information and facts. I know you all read stuff where you start it and at the end you think, what have I actually learned? So articles really should supply information and share between us, not just be a sort of a very much an overview. And I'd love to have articles because you all have incredible experience, and if we could share that experience, we would all have a better knowledge and understanding. So that's it. Well, I look forward to seeing you all on the 17th of December. So don't forget to sign up. You'll all get an email and the link tomorrow. And once again, thank you, Donald and Malith. I know now for some of you it's very late. Donald, definitely Coco, straight into bed. And for those of you who are just getting up, well, lucky you, because it's still a long day ahead of you. Thank you all very much for attending. And as I say, if I can be of any help to anybody, then you've got my email address. And right, Toddy bye to you all. Okay, cheers.
Bye.
Bye.
Bye.